Well, good evening to India and good morning from here, a rather cold morning. Today, as you know, or this evening, we're going to talk about trade remedies, in particular anti-dumping, countervailing duties, subsidies, etc. It's a very active area. And in fact, out of the less than 600 cases brought in the new WTO system, dispute settlement system, around 200 have involved either subsidies, countervailing duties, or anti-dumping. So it really is the most litigated area, also the most controversial. Indeed, that really, it's various decisions by the appellate body in these trade cases that led the US to stop nominating people to the appellate body, which has meant basically the dispute settlement system for the moment is defunct. So you can see why it's important. As we will see later on, India has played a very active role in trade remedies. So we're going to start to talk about subsidies and countervailing duty measures. And I'm delighted to introduce my old friend and colleague, Spencer Griffith. We've worked together for 30 years, 40 years, long time. Long time. I had more hair. Well, Spencer's not gray yet, but he's getting there. And Spencer and I, well, first of all, Spencer is one of the top trade lawyers in Washington. And in particular, he has represented the government of British Columbia in a massive subsidies case, which, if you can believe it, has been going on since the early 1980s. It's got my children through college and probably Spencer's as well. It has gone on and on and on, and it involves billions of dollars of trade. Probably not as big as Airbus, but certainly one of the very largest cases. So anyway, and I should explain that Spencer and I, Spencer's taught this many times in courses I've been organizing, and we tend to, I tend to interrupt him a good deal. He doesn't seem to mind. We go back and forth. It was quite funny. We did some work in Japan, and we'd been with our clients. And of course, as you know, the Japanese are very hierarchical, and they couldn't believe the fact that this, I mean, Spencer's taller than me. He's actually the second tallest trade lawyer in Washington. He's 3 inches taller than me, but he was very clearly younger than me. I looked a lot older, and they couldn't believe this young whippersnapper was interrupting me and said, "No, Patrick, you're wrong. This is, you're completely wrong about this." Anyway, so just to warn you that I may speak more than I should. But anyway, so Spencer, it's over to you.
Thank you, Patrick, and good evening, everyone. Nice to meet you by Zoom. As Patrick mentioned, I work in the trade area. I actually specialize in subsidy cases, and as we'll talk more about today, personally, I find them more interesting than dumping cases because they involve government policy, and we'll get into that. But one remark about Patrick MACRORY first. I think you all are lucky to have Patrick be one of the organizers and main presenter for you this week. Perhaps as in India, I don't know, but in the US, trade lawyers have gotten very, very specialized. I do a lot of subsidy cases, for example, some WTO cases, and a few.
Again, we seem to be having trouble.
Yeah, it's Spencer's connection.
But for the most part, trade lawyers are really special, and why he's a good teacher for these. And most trade lawyers.
Spencer, one thing, your connection is freezing. Maybe you might want to close your email program.
Okay, how do I do that? Okay.
Close your email program. Yeah. Yeah, minimize Zoom.
Yeah.
And then close your email program so it doesn't use your internet connection.
Okay, I'll try that.
It seems better already, actually.
Yeah. Okay.
Yeah, if it keeps freezing, then we might try to stop your video and only have the PowerPoint on the screen.
Yeah.
Okay, so now go back to Zoom.
Can you see me now?
Yeah, yeah,
But we can't see the slides.
You cannot.
No.
yeah. You need to click on the share screen on the Zoom.
I'm sorry, Gorgon. I don't see the share screen.
You see our video?
No, I only see the PowerPoint.
Okay, at the bottom you see the Zoom icon, the blue square with the white.
No, I don't. I
Okay.
only see the PowerPoint.
Okay, Spencer, this is Bob. Off to the right, you see a little square where you see a video.
No, I don't. I
Don't
only
see a
see
video at
the only
all?
thing on my screen is the PowerPoint.
Okay, minimize PowerPoint in its entirety.
I'm trying to. I can't minimize it.
Okay, hit escape.
Okay, there it is.
Okay.
Yeah, but we can still only see you and me.
Right, and then hit share screen, Gorgon.
Yes, yes.
I think it's coming. I think. Yes, here we go. Okay.
And then do from the current slide
Yeah.
in the left side, on the left side.
From
the
beginning.
current.
Yeah,
Okay.
that's fine.
Okay, there we go.
All right.
Try again. Yeah, I don't know what happened to the connection. Okay, so what? As I was saying, Patrick is well versed in all these areas of trade law, so it's great to have him as an instructor for you this week. Today we want to talk about subsidies, also called countervailing duty cases. You hear that term interchangeably, so don't be confused by that fact. What we'll talk about is how subsidy cases are different than dumping cases, the WTO agreement on subsidies and countervailing measures, WTO versus domestic law subsidy cases. I'll discuss a few examples of key U.S. cases. We'll discuss the definition of subsidy. It's a three-part definition. And then current issues in subsidy cases and some remarks about the U.S. subsidy cases against India. And then if we have time, a little bit more on WTO cases on subsidy. So the issue in subsidy cases is how to discipline, if at all, the government provision of something of value to companies that export their products and allow companies to export their goods more cheaply than they otherwise could. The government could give a grant, the government could give a loan, the government could provide low-cost inputs like water or land, the government could provide favorable financing. That, of course, is the Airbus example where the EU government gave favorable financing to Airbus. There's a whole lot of different ways that governments can offer assistance to industry. And the point of the subsidy law is to determine when that assistance is allowable and when it is not, and how cases should be handled and processed dealing with subsidy cases. So the purpose of the subsidy law is to address distortions in international trade that occur as a result of government giving a subsidy to their producers. Now, Patrick is going to talk later about dumping cases. Many economists, I'm sure Patrick will get into this, will tell you that in their purest form, dumping cases often don't make a lot of economic sense because there may be a whole lot of reasons why a company will sell in a foreign market at a lower price than it sells for in its home market. But to an economist, at least, the subsidies law makes some sense because when the government of a country is providing things of assistance to exporters, that government is distorting the efficient allocation of resources in that economy, right? If the government gives $1 million to a steel mill, that's going to mean more steel is produced than would otherwise be the case in an efficiently operating market. And that's not a good thing. But, and here's the real tension in subsidy cases, governments do things all the time to benefit society. They provide jobs, they build bridges, they build roads, they build hospitals, they build highways, they promote exports. So how do you draw the line between when the government is distorting the efficient allocation of resources and when the government is just doing things to help the entire society? That's the fundamental tension at the heart of subsidy cases. So following up more on this distinction between dumping cases, Dumping cases, as Patrick will talk about later, involve the pricing behavior of individual companies. In contrast, subsidy cases involve governmental action. The government is doing something, giving something of value to an industry that is exporting its product to foreign markets. So right there, you see a fundamental distinction. These subsidy cases are involving governmental action. And if you're a lawyer like me or Patrick working in Washington, that by itself is interesting because subsidy cases raise governmental policy concerns. Why is the government taking this action? Why is the government favoring a particular industry? How is the government favoring a particular industry? And if you're interested in policy and you're a lawyer, there's a natural affinity for trade law because these are governmental policy actions. Now, so the good news to a trade lawyer is while subsidy cases are interesting because you get into governmental policy, the bad news is there's not that many subsidy cases anymore. There used to be a lot more subsidy cases, but over time, governments got better, frankly, at giving assistance to industries in a way that does not violate the trade law. And so right now, there are thousands of dumping cases worldwide. And as the slide says, there's roughly about 500 CVD cases, also called subsidy cases.
Yeah, just to interrupt quickly,
please.
I've got the exact numbers in my presentation on anti-dumping, but it's about 5,000 cases on anti-dumping. So it's about 10 times as many dumping cases as countervailing duty cases and subsidy cases. So it's really a big, big difference.
Yeah, and most of the subsidy cases are in the steel and chemical sector, in part because those sectors are capital intensive. It's very expensive to build and operate a steel mill or a chemical plant. And that's one reason why there's a lot of governmental involvement. And the interesting thing as well about subsidy cases is that there are now many, many subsidy cases against China. 20 years ago, there were mostly only dumping cases against China. Now, at least in the US, almost every time a dumping case is filed against China, there's a parallel subsidy case filed against China as well. So that's a fundamental change in how subsidy cases are managed. So the countries most often hit with subsidy cases are, not surprisingly, China, but then also Canada, India, Korea, and Italy. Those are the leading countries that are most often hit. And interestingly, India is the second most often hit country, behind only China. There's 52 subsidy cases in place against India, far fewer than China, but more than any other country besides China. So the major users of the subsidy law, and by that I mean which countries file the most cases against imports. So the biggest users of the subsidy law are the United States, Europe, and Canada, with the US being by far the main user of the subsidy law. Interestingly to me, and I'm not sure why this is the case, India doesn't use CVD cases very often. It doesn't file subsidy cases against imports. There's only currently 7 cases in place in India against imports. And I'm not sure why that is. I think, Patrick, India is a much more frequent user of the dumping law.
Huge. We'll get into that later. But
exactly.
Yeah, it does surprise me, particularly why India doesn't file more countervailing duty cases against China, because everything's laid out. The US has brought many, many cases, and many of the programs are broad programs, which obviously apply to exports to India as well as the United States. So in a sense, all the work has been done by the US petitioners and the US Commerce Department in describing these programs and why they are illegal under the WTO. So it does surprise me. Maybe when we have the Q&A later on, maybe somebody in the audience will have some ideas on that. But as I said, it's all there. You just have to take the US decisions and apply them to Indian imports to India from China.
Yeah, it is interesting, and I'm not sure why. China, of course, is now the main target worldwide of both dumping and subsidy cases. The other major macro trend is trade cases are increasing again. Trade cases go up and down generally with the economy. They're countercyclical. That means when the economy is doing poorly in a given country, you tend to see more cases filed because the domestic industries feel they need help from their government. And there's also a political component as well. If domestic industries feel that their government is more likely to impose tariffs on imports, does that remind you of any administration currently in place in the United States? You will see an increase in cases as well, apart from macroeconomic reasons as well. Okay, so let's turn then to what are the guiding legal principles that determine how subsidy cases are handled. Patrick and others this week, if they haven't already, will be discussing with you the various agreements that are in place under the WTO. The relevant agreement here for our purposes today, is the Subsidies and Countervailing Measures Agreement, the SCM agreement. The SCM agreement is one of the WTO agreements that was negotiated and is really one of the major accomplishments of the last trade round. I do not think it would be possible for the United States ever to agree, or much less lead negotiations on curtailing the use of subsidies worldwide that the US did back in the Uruguay round. And so the SCM agreement is—
Spencer, can I just interrupt for a second?
Yeah.
A little bit of history. There are some provisions in the original GATT dealing with subsidies, but they're very weak bans on subsidies. We don't need to go into detail. Also, there is a provision saying you can apply countervailing duties to offset the effect of a subsidy, but there was no definition of subsidy. It was a very short, about one paragraph. So there was really almost nothing there. Countries had a huge amount of flexibility in how they define subsidies, and so when they could apply countervailing duties. So this really is a huge sea change because it's a very detailed agreement.
Right. So two major accomplishments, two major themes of the SCM agreement. As Patrick mentioned, while there was some very ambiguous discipline in place under the GATT for the use of subsidies, the SCM agreement for the first time ever set out a very detailed definition of what is a countervailable subsidy. You think that's a pretty obvious thing to do, but it took until the SCM agreement for that to happen. The second major theme and accomplishment of the SCM agreement is that it clarified the procedures and obligations that countries have to comply with when they are imposing duties, countervailing duties on imports that have been subsidized. So number one, it sets out a definition of what is and is not a countervailable subsidy. And number two, it says, right, if you're going to go after imports that are subsidized, these are the rules that you have to follow when you are imposing duties on imports. This was a difficult agreement to negotiate, and it really, I think, stands out as one of the major accomplishments of the round, because this was sorely needed and is something that has done a lot of good in the past. Okay, now this discussion here is something that trade lawyers always like, and it's one reason why some people feel that the law is too complicated. But let's get into it. If you're a domestic industry that's hurt by imports that are subsidized by a foreign government, the SCM agreement sets out two tracks or two courses that you could follow. Number one, you could convince your own government to go to Geneva and file a case in Geneva under WTO rules. Okay, that's, for example, what the US did with Airbus. They went to Geneva, and 20 years later, they're still fighting about how to resolve the Airbus-Boeing dispute in Geneva. The second thing that a domestic industry could do that's hurt by subsidized imports is they could go to their own government and file a case under their own domestic law. Okay, so it provides for two tracks. Number one, you could go to your government, and your government can fight it out in Geneva with the other government. Or number two, you could go to your own domestic agencies. In the US, we go to the US Commerce Department and ask them to investigate and determine if there are subsidies being conferred, okay? And this possibility exists in every case.
Just to
So
say,
let's look
sorry, just to interrupt again, the remedy in a countervailing duty case is, of course, countervailing duties. So you get the imports that are subject to receiving subsidies then pay, there's an extra duty paid. Whereas in the WTO, basically the WTO says to the offending government, stop. And if you don't stop, you'll be punished. And we'll deal with all that when we get to dispute settlement. So, sorry, just to clarify.
Right, right. Yeah, that's important. That's important. Thank you. So in the first scenario, in the first track, the challenge under the WTO rules, let's look at a good example of how this might work. And let's take the Boeing-Airbus fight as an example. As you may know, the real competition for aircraft is not really in the US, it's really in Asia and the Middle East, right? So let's say that country A, the EU, subsidizes Airbus exports to C, the Middle East and Asia, okay? And country B, let's say that's the United States, Boeing's exports to the Middle East and Asia are impacted by the EU subsidies to Airbus, okay? So in that scenario, the two producers, Airbus and Boeing, are fighting it out in a third market. So Boeing convinced the US government to go to Geneva and bring a case in Geneva under the WTO rules against the EU alleged subsidies to Airbus, okay? So this is an example of a multilateral fight being handled in Geneva under WTO rules. That's the first track. The second track, which could be done, would be to proceed under your own domestic law. So let's say country A, let's say it's Korea. Korea government subsidizes exports of steel from Korea to the United States. Okay, and country B, let's say, is the United States. The US steel industry is injured by imports of subsidized steel from Korea. Okay, so in this scenario, the United States can investigate at the request of the US steel industry whether those imports of subsidized steel from Korea are harming the US steel industry and whether there are countervailable subsidies being imposed. Okay, so this is the other scenario, the other way that subsidy cases can be fought out. Now it gets more complicated because let's say in this example that we have on the screen, the US government does impose countervailing duties on imports of steel from Korea. And let's say they impose a tariff of 20% to offset those subsidies. If Korea isn't happy with the outcome of that subsidy investigation, Korea, country A in this example, can then go to Geneva and file a case in Geneva under the WTO saying that the US didn't follow the WTO rules in imposing this subsidy. I mean, for example, it used an improper definition of subsidy, or it made mistakes in calculations, etc. So even in this scenario, you can have a situation in which WTO rules and dispute resolution still come into play. And that's that example here, okay? So as Patrick correctly mentioned, the outcome of a subsidy case under your own domestic law is to have tariffs imposed on the imports. And if the US Commerce Department says there's a 10% subsidy being imposed, then the US government will put a 10% tariff on imports of the product. And let me tell you a few examples. One of the biggest cases ever was the lumber fight between the US and Canada. The US lumber industry said that imports of lumber from Canada were being subsidized. And the case was brought under US law. Huge case. I've worked on this case for over 20 years. Patrick's worked on this case as well.
Every trade lawyer in Washington has worked on the case.
Exactly. Yeah.
I worked out once that there were 80 lawyers representing the various Canadian interests, and it was I always called it a transfer of wealth from Canadian taxpayers to Washington lawyers, which seemed to me to be a very, very good idea.
Exactly. There's a lot of money at stake in these cases, and so what happens is every party who has a financial interest in the case hires their own law firm, and as Patrick mentioned, sometimes you'll have council meetings. I've been in council meetings with 15 to 20 different law firms, each of which has multiple lawyers at the table, as Patrick just mentioned. So
can I just add one more point? The subsidy, alleged subsidy, there was of course no subsidy because we represented the Canadians. Virtually all the trees in Canada are owned by the provincial governments, and the argument made by the US industry was that the governments were selling the right to cut trees at too low a price. In other words, that was the subsidy, giving something of value. We're going to charge you $10 to cut a tree down, but the real value should be $20. So there's a $10 subsidy.
Right.
Unbelievably complicated, thousands of pages. What is the true value of a tree?
Right.
Not easy.
So
a week course on that, I think.
Yeah.
A week long. I mean, not a week.
So we had, each side had economists and lawyers and statisticians. Huge case, very complicated case.
And I would just add that we've had certainly one, I think, 2 Nobel Prize winning economists working for the Canadians. That was quite. I mean, this is high level stuff.
Yeah. And the U.S. government has imposed duties on imports of lumber. Canada has filed multiple challenges in the WTO, and I've worked on those challenges as well. This is public. About 6 months ago, Canada won, total victory at the WTO before the panel. But the U.S. government, as Patrick said at the outset, has basically made the WTO appellate body non-functional anymore. And so Canada won the appeal to the WTO, right? Okay. Number one, the U.S. has basically sunk the dispute resolution system by refusing to name new appellate body members. So what does the U.S. do? It appeals the Canada's victory in the lumber fight to this non-existent appellate body, which means the U.S. doesn't have to comply with the panel decision that Canada won. You could take a cynical view of that.
To clarify, it won at the panel level, the first level.
Yep.
And then now the case goes into limbo because there's no appellate body.
It's unbelievable. The Airbus dispute, I talked about that earlier. Both sides filed WTO cases against each other. The U.S. government said Airbus receives subsidies. The Europeans said Boeing receives subsidies. The WTO system said both sides are right and allowed retaliation and tariffs against each side. And that case, like lumber, has been going on for 20 years. It's unbelievable. The final case is the U.S. case against paper from China. The U.S. government used to say that we can't file subsidy cases against China because the entire economy is distorted. Remember I said at the outset that the point of the subsidy law is to address distortions in trade in an economy. And so in the Chinese economy, if the entire economy is distorted, the U.S. government said, well, we can't then measure subsidies. How do you measure subsidies if the whole economy is distorted? But in 2007, the U.S. petitioners, the U.S. industry in various cases was complaining. They said, look, it's not fair to us. We can file dumping cases against China, right? But we can't file subsidy cases against China. That doesn't seem fair. And so the Commerce Department reversed its position and said, going forward, we can measure distortion in the Chinese economy well enough that we can have a subsidy case. But so there's an expression in English, have your cake and eat it too. So in a dumping case against China, as Patrick will discuss later with you, the U.S. government applies a pretty unfair non-market economy methodology on the assumption that the economy is so distorted, you can't trust the prices and costs in China. And that results in very high dumping margins against China. At the same time, the U.S. government says, well, in a subsidy case, we can measure distortion in the Chinese economy, so we will allow subsidy cases to proceed against China. It's, as you can imagine, it's that's a tough position for Chinese exporters to be in. Okay, let's talk for a minute about the definition of subsidies under both the WTO and under US law. And before I get into this, let me just add one explanation. Remember I said that the WTO sets out the rules for how you define a subsidy, okay, for the first time ever. Each WTO member country, including India, the United States, China, everybody, took those WTO rules and incorporated them into their own domestic law, okay? So if, for example, if you look at the US statute, it follows almost word for word the WTO rules on how you define a subsidy, okay? And most governments, Canada, the Europeans, I assume India, do the same. So again, the WTO sets out the high-level rules, and each individual member country then has to implement those rules under its own law. Okay, so the definition of a countervailable subsidy is three parts. You need, number one, a financial contribution, and we'll come back to each of these, which provides a benefit to the company and which is specific, okay? So you need all three of those things. If the respondents win on any one of these, that means there's no countervailable subsidy. So for example, a loan provided by the Korean government at a commercial rate is not a subsidy, right? Because no benefit is conferred. That Korea Steel Company could have gone out to the market and gotten the same loan from a commercial bank. Therefore, under this three-part test, that's an example of why there's no benefit and thus no subsidy. So let's go into each of these three examples. Financial contribution. This basically means the government gave something of value to the company or to the industry, okay? And there's four examples. I'm sorry, they're not examples. There's four types of financial contribution that are addressed. Number one, direct transfer of funds. That would be a grant, a loan. If you bought stock in the company, that would be the direct transfer of funds. Or government revenue foregone, which the best example is a tax credit. The Korea government says, well, normally this steel company would owe $1 million in taxes, but we'll say they only owe us $10,000 in taxes. That would be a tax credit, which would mean the government did not get the money it was otherwise due. Or the provision of goods or services for less than adequate remuneration. That's a mouthful, but that means the government gave you something for less than it was worth. The lumber example that Patrick and I mentioned is a really good example of that. And the example there was in Canada, the governments own the trees, they own the forest, and the government sells those trees to lumber companies for less. The allegation is they sell those trees for less than they're worth. And thus the government is giving a good, the standing tree, to a lumber mill for less than it's worth, okay? The final example is the hardest one, and that is it entrusts, the government entrusts or directs a private body to carry out one of the above three elements. The best example there is, again, in Korea. I worked on this case. The Korea government kind of convinced a Korea private bank to give low-cost loans to a semiconductor manufacturer. And the Korean company said, well, it's not a subsidy because we got this loan from a private bank. That's not the government. And the US government said, no, no, no. Under this entrust or direct standard, the government basically pressured the private bank to offer a low-cost loan. And therefore that can be a financial contribution, okay? Usually this element is not fought over that much by the lawyers in these cases, okay? So let's move to the second leg of the test, benefit. And remember that I said the assistance has to provide a benefit to the company. And the benefit basically means, did you get something from the government on better terms than you could get it from the market? For example, as Patrick knows well, back in the day, the British government was trying to prop up the failing British steel industry and was trying to purchase stock in steel companies. And the question there becomes, if the government purchased stock on terms that no private investor would have purchased that stock on, that might be what's called an equity infusion. The government was infusing money into the company by buying stock when no reasonable investor would have bought stock, kind of a reasonable investor test, okay? You don't see these cases very often anymore, but 20, 30 years ago, you used to see a lot of them. It's interesting, Patrick, I don't know why we don't see these equity infusion cases anymore, but they're pretty rare these days. So.
Well, I think, governments, again, it's, Thatcher, other people, governments are not investing in industry nearly as much. I think it's part of the free market.
Right, yeah.
And financial. I mean, it costs money, and governments don't have as much money as they used to.
Right,
I would think.
Right. A loan is an easy example. If the commercial rate on the market is 5% on a 5-year loan, and the government offers you a loan at 2% on a 5-year loan, the difference between 2% and 5%, that delta would be a benefit, right? Because you got that money for less than you'd have to pay for it on the market. A grant. If the government writes you a check for $1 million, guess what? That's $1 million subsidy. We don't see these cases very often, grants. Governments have gotten much smarter over time, and we just don't see many grant cases anymore. So loan guarantees are easy again. If the government gives you a loan guarantee, sometimes they do that for free, then the difference between what you paid the government for that loan guarantee and what you would have to pay for on the market, that difference, it would be a subsidy. All of these transactions are measured from the viewpoint of the recipient. That means the company, not from the viewpoint of the government. For example, a loan guarantee. If the Korea government, I'm sorry for picking on Korea, but it's just an example. If the Korea government gives a loan guarantee to a Korean semiconductor producer and doesn't charge a fee, that doesn't cost the Korea government anything, does it? No, it doesn't. So you might argue, well, how can that be a subsidy? Because we, the government, didn't pay anything. But under the WTO rules, you look at the transaction from the viewpoint of the recipient, from the company. And the company still got a benefit because it didn't have to pay for that loan guarantee, even though the government didn't pay anything out of pocket, didn't cost the government anything, okay? So the final point I want to make on benefit relates to this provision of goods or services. We talked about the lumber example. This provision of goods or services is very, very common now, including in India cases. The best examples here is where the government either gives or sells at a low price inputs like land or water or electricity that the company then uses to make the goods that it exports. And there have been US cases against India where the claim was that the government in India was giving land and water and electricity at low rates to the company. So we see a lot of these provision of goods or services. The difficult thing with this type of claim is, how do you measure what is land really worth? What is water really worth? What is electricity worth? How do you value that? And this has been a source of a lot of litigation. It gets very fact intensive. There's very few overarching principles other than when you're in the middle of these cases, you're trying to find some independent market value for the item. What's the independent market value for land or water or electricity or chemicals? You can imagine what it is.
Spencer,
these are tough. Yeah.
Question. In the various lumber cases, there have been actually 5 iterations of the lumber case. How many different definitions of adequate remuneration have there been? For example, there are a few private auctions in Canada. Well, do you use that? It's a private market, but it's very small. And so it may be distorted by the massive government activity. Do you look at prices in the United States? And at some points they've done that. Do you look at the cost of the forest? Well, they didn't actually cost anything because they were there when the governments were formed. So
Yep.
incredibly difficult. And we always use the analogy of a hydroelectric plant. Is there a cost to the water that is driving the plant? Does it have a cost? Who's paying for it? And the very difficult. And one reason Spencer was saying they're much more interesting cases because you're really involving some quite esoteric valuation issues. With dumping, it's all about numbers and cost, and so very different.
Right. Yeah. And in the lumber case, Patrick makes a good point. There, this case was going on for 20 years, and there's multiple
30, 40
cases.
years, Spencer.
Yeah. And as Patrick said, the U.S. government has tried to value the market value of a standing tree in the forest so many different ways. And in the most recent current case, they are valuing what the forest in the province of Alberta, which is in far western Canada, next to British Columbia, by looking at the value of trees in Nova Scotia, which is in far eastern Canada, 3,000 miles away. And the U.S. government says, well, that's a good way to measure the value of the forest in Alberta. Really?
Different
it
climate,
shows you how
different trees.
difficult the provision of goods and services analysis is.
Spencer, this is Bob. Sorry to interrupt. We do have a couple of questions. Rather than have them build up too much, maybe we can just take a short break, and I'll allow you and Patrick to intercede and try to address these.
Sounds good.
Yeah. So the first question is, what if a company undergoes an insolvency process or is on the brink of insolvency and requires equity infusion?
Okay. Good question. So in that example, if a company that's being investigated had either gone insolvent or near insolvent, and the government purchased stock in the company or invested in the company otherwise, under the rules, it's basically a reasonable investor test. Did the government invest on terms that a reasonable investor would have invested on? For example, would a reasonable investor have required greater collateral from the company? Would a reasonable investor have charged a much higher interest rate to recognize fully the risk of the investment, etc.? These are tough cases. There have been some of these reasonable investment cases. They're factually difficult. You usually have to get economic testimony and investment advisor testimony, but that's how it would be analyzed. Patrick, anything to add?
Well, simply that if the company is on the brink of insolvency or has gone insolvent, as you said, a private investor would require a lot of collateral and probably a high interest rate, and the government probably is not, because they're trying to preserve the assets of the company. So I would think there'd be a pretty high chance of a finding of a subsidy of a benefit. Yeah.
Agreed.
But you have to look at the facts. In every case, you have to look at the actual facts and apply those tests.
The next question is, can a loan given at a concessional rate, which is much less than the commercial rate, I would suspect, be a subsidy per the definition of WTO?
Yes.
Simple answer, it's a benefit. It's clearly a benefit. Because basically, in determining whether there's a benefit, you're looking at the market. What is the market charging? What is the free market? What are banks charging for loans? And you try to find loans, similar length, similar duration, similar conditions in the private market. That's always when you're dealing with loans. So yeah, the answer is definitely, in that case, yes.
Okay. What if the benefit is given to an end consumer? Like if the government comes out with a scheme of providing tax credits to consumers if they buy a certain good. I suppose maybe a good example, this is my illustration, maybe a good example several years ago was the purchase of cars under the past administration, I think.
Yeah.
Wow. Great question.
Great question. Yes.
Great question.
What if, you're right. Supposing the government said, right, anybody who buys an American car, we're going to give them a nice little tax break, a tax credit. They can deduct this from their their taxable income? And it's a very good question. I offhand don't know the answer, but
I would agree, Bob. I've never seen that scenario. Boy, I guess you'd have to argue it was indirectly providing a market promotion to the company. Boy, I'd like to litigate that case. Either side, that'd be a fun case.
I'll tell you the other thing. If you're benefiting American cars, I think you'd have a national treatment problem under Article 3 of the GAP. So you might not even use the subsidy, the SCM agreement, but certainly that would be a national treatment violation without any question at all, I think.
So, Bob, I think that is an excellent question. I think, like Patrick, I've never thought about that scenario. I've never seen it. It'd be a tough case.
Okay.
I don't know the answer.
Okay. The next question is, if country A's subsidy is challenged by country B's industry in country B's domestic courts, leading to tariffs levied against country A, can country A then challenge the tariff under the WTO laws?
Yes.
Absolutely.
Yes. And that's a good question. And I think I gave an example. The U.S. imposed subsidy duties on imports of lumber from Canada, and Canada went to the WTO and said the U.S. government did its calculations wrong. They used the wrong benchmark. Their calculations are full of mistakes. And Canada argued that in the WTO, and Canada won in the WTO. The problem becomes, and Patrick will discuss this later this week, what's the remedy? If you win the WTO, your remedy isn't necessarily as concrete as it might be. But in that scenario, yes, country A can challenge the case in the WTO.
Okay.
Just to add one more point, if you don't mind, we've talked about the two remedies, the WTO remedy, where you go straight to the WTO, you bring a case, and so on. The other is countervailing, but it's very important. These are not either or. You can do both. And in fact, a lot of people thought that Boeing, having persuaded the US government to bring a case in Geneva with the WTO, might also file a countervailing duty case against imports of Airbus aircraft in the United States. So it's not either or. You can do both. Boeing didn't. And another important point is, and Spencer brought this up, but I think it's worth emphasizing, virtually all the cases brought under the direct attack in the WTO in Geneva have involved the competition in third countries. Because if Boeing had brought a countervailing duty case against Airbus, that would only apply to imports into the United States. They wouldn't apply to import or exports to China or to the Middle East. So I think that's an important distinction. And so, as I said, most of the cases, because it takes longer in the WTO, the remedy isn't so clear. It's definitely their advantage to countervailing duty quicker, and you get a very clear remedy. You get the duty on imports, but it doesn't apply to third country markets.
Okay, and Spencer, the last question, and then I'll save any additional questions for later. Are subsidy cases made based under the national treatment and MFN clauses?
No. That's an interesting question, but no. A subsidy case is filed under the authority and rules set out in the SCM agreement in the WTO. And when you're in a subsidy case, issues of national treatment and MFN are not that issue. Those
all cases, all dumping and countervailing duty cases in every country are filed against a particular country. They're very much country specific. So you get a case against, I think there was a case against manhole covers from India many years ago. All sorts of strange products get subject to these cases, but it's absolutely country specific. Separate case. There might be a case filed at the same time against several different countries, but each case would stand on its own. It would be a separate case, and so that's very clear.
So you can think of subsidy cases, and again, that's an interesting question. I mean, subsidy cases and dumping cases create basically an exception to MFN tariff levels, right? You could have a 5% duty on imports of cold rolled steel that applies to everybody, all countries worldwide. But if there is a subsidy and or dumping case against Korea, Italy, and China on cold rolled steel, the tariffs from those countries, I'm making this up, could be 20, 25, and 30%, and everybody else pays 5%. So they're authorized exceptions to MFN. Okay.
Spencer, I've got bad news.
Yeah.
We've got 10 minutes left.
I know.
I'm going to ask one last question, then I'm going to hold off anything else. But this is, I think, a follow-up. What if the government is infusing funds into a sovereign enterprise, for example, Air India? Would this still be a subsidy, considering both could be considered state?
Yes, that's another good question. Yes, state-owned enterprises are still subject to the discipline of the subsidy law. The best example is China. There have been a lot of subsidy cases against China, and the issue arose, well, this is a state-owned enterprise, an SOE as they're called in trade law, and do the disciplines of the subsidy law still apply? So in that example in the question, if Air India is a state-owned carrier, I don't know if it is or not, but assuming Air India is a state-owned carrier and assuming Air India receives subsidies, then those subsidies could, in theory, still be subject to a countervailing duty case.
Well, let me add a caveat, and this is a very important point, which is that the countervailing duty law, the SCM agreement, only applies to trade in goods. And of course, air carrier is a service. There was some effort in the Doha round to bring countervailing duties into services, but they got nowhere. They couldn't figure out how to do it. So I think in that case, but so it has to be a manufactured good or the producer, which is subject to the SCM agreement. But it's a great question.
Yeah.
We do have questions, but I'll hold the remainder until.
You've now got 8 minutes, Spencer.
We're good. We're good. The last leg of the three-part test for a countervailable subsidy is specificity. And this goes to the notion, as I said at the outset, that governments take action all the time to benefit the country. I mean, that's what governments do. They build roads, they build bridges, they build hospitals. And if a government is taking action that benefits everyone, what's it doing? It's not distorting the efficient allocation of resources in that economy, right? If it builds a highway that everyone can use, you're not going to make more steel than you otherwise would, because everybody can use the highway. So a subsidy has to be specific to be countervailable. In contrast, if it's generally available, which means if it's available to everyone, then it's not a subsidy. For example, what if a government reduces the corporate income tax rate from, I'm making this up, 30% to 15% for every company in the country? Is that specific? No, because every company in the country benefits from that reduction of the corporate income tax rate. So that's not specific. In contrast, what if the government says, okay, right, the corporate income tax is 30%, but because we want to encourage the production of steel, we're going to reduce the corporate income tax rate for steel mills to 20%. Is that specific? You bet it is, right? And the difference, the subsidy is the difference between 20% and 30%, okay? So specificity used to be litigated a lot. Back in the old days, Patrick and I and other trade lawyers, we fought over specificity and we came up with clever arguments as to why something was not specific.
And if I can just interrupt, we won in one case and then Congress changed the law. It was,
right.
Canadians kept saying, you're moving the goalpost. How can you do this? They got very angry. So just give one more example, just to give you an idea of where these cases fall. There was a case against Mexico. All farmers were getting free water. And the Commerce Department said, no, that's not a subsidy because it's really available to so many different farmers of any kind. Now, on the other hand, a subsidy just to pig farmers, that's specific. But what about a subsidy to all livestock? Is that specific or not? I don't know. I don't think that's ever been litigated. But to give you an idea, there's like many WTO issues or trade issues, there's a spectrum. On one end, you can really like product. At one end, you can say it's not a like product. On the other, you can say, yes, it is a like product. But in the middle, there's a whole range. And I think that a lot of trade cases or trade issues deal with this spectrum.
Right. And in the old days, governments weren't so smart about this, and often on the face of the law, the statutes themselves were written in a way that created specificity. And we call that de jure, in law specificity. Governments have gotten smarter over time, and they don't do that anymore, because if the law on its face was limited to certain industries or certain companies, then that was obviously specific. The other type of specificity is de facto or in fact specificity, and that's what Patrick was just mentioning. And so to determine if something is in fact specific, you look at whether there's a limited number of companies that got the benefit. You also look at predominant use. Even if a lot of companies got the benefit, did a few companies receive most of the subsidy? You also can look at disproportionate use. Did a few of the companies receive the largest dollar amounts of the subsidy? And finally, you look to see if the government exercised discretion, right? When the government was deciding who gets the benefit. Does everybody get the benefit automatically, or does the government get to pick and choose who gets the benefit? And so these are all factors that you look at in any given case to see if there's specificity.
If I can just use one more example from the lumber case, the various provincial governments built roads into the forests. And the question was, in each case, was the road basically just built for the lumber industry so that they could cut the trees and bring them out, in which case it is specific, or was it for general use? And so you look at how the roads are used, and that's the kind of issue that comes up.
Okay, so to summarize then, you need a financial contribution, which means that the government gets something of value, that confers a benefit, which means that the company get it on terms better than it could get in the market. And finally, that benefit is specific, meaning it doesn't go to the entire economy. If those three things exist, then yes, it's a countervailable subsidy. Okay, switching gears, I looked at 4 or 5 of the most recent US subsidy cases against India. And you see those 4 cases there in the first bullet point. I was curious to see how high are the margins in US subsidy cases against India. They were quite low, which is good news. In cases against China tend to produce high subsidy margins, but in general, if you take a step back, subsidy margins are usually lower than dumping margins just because governments have gotten better at giving out assistance. So in these recent 4 India cases, the margins were generally low. There was one exception. There was a duty drawback program that resulted in a high margin in the steel rod case. There was one of the India cases had adverse facts available. That means the US Commerce Department sends out these written questionnaires, and if the company or the government doesn't answer the questionnaire, then the US government says, right, you're not cooperating, we're going to give you a punitive high rate. And so this is interesting for India lawyers, because in a subsidy case, both the India companies and the India government have to answer questionnaires, okay? And so if the India government fails to cooperate, then that will result in a high margin for the company. Also, in these India cases, we had examples where the India government was providing water and land that the factories were using at low rates, and the US Commerce Department countervailed the provision of water and land because they said it was provided at too low a rate. And the final point, this just came up recently, this last bullet point here, the US government very recently moved India off the list of developing countries for trade law purposes. And because of that change, the de minimis threshold has been reduced to 1%. That means if a subsidy comes in at 1.5%, tariffs will be imposed because India is now considered a developed country by the US, whereas in the past, it was a 2% threshold when India was considered a developing country. So
just to clarify one point,
yeah.
I think I'm right in saying that it's not each individual subsidy less than 1%, but all the subsidies that have been investigated and ruled on, if they're collectively less than 1%, then it's de minimis. But
that's correct. That's correct. Right. So these are some of the interesting, findings in the recent India cases. Given where we are on time, there's just one last slide I just want to walk through with you quickly, and then we'll have a few minutes for questions. What are some of the current subsidy issues that the trade bar is seeing? One of the ones most interesting to me is, despite years of threatening to file a currency case against China, the U.S. Commerce Department, in its wisdom, has filed a currency valuation case against Vietnam, claiming that the Vietnam government is subsidizing its exporters by keeping its currency exchange rates artificially low. And very difficult case to prove, very controversial. Many people claim that the SCM agreement should not be applied to currency valuation issues. For example, the International Monetary Fund says it should not be, and this case is going to really become controversial. It's just at the preliminary stage now, and the U.S. Commerce Department preliminarily did find that Vietnam conferred a subsidy as a result of low currency rates. I think a lot of countries around the world are watching this Vietnam case carefully to see where this goes. Secondly, countries around the world, governments around the world, are providing assistance to industry as a result of the COVID virus. I'm sure the Indian government is, I know the US government is, I know the Europeans are, I know the Canadians are, I know the Chinese are, everyone is. So in theory, some of this assistance probably could be countervailed. We'll have to see if that happens. Back in the 08-09 recession, when governments were providing assistance to industry, most of that assistance was not challenged in a countervailing duty case. I think there was kind of an unwritten gentleman's agreement among governments not to do that. There was one exception. China filed a subsidy case against US government assistance to the auto industry. And not surprisingly, the Chinese trade authorities found that the US government had subsidized the US auto industry. But that was the only case I'm aware of worldwide where any of that was challenged. So we'll have to see over time if governments challenge each other's provision of assistance to industry. I think they will not, for obvious reasons, because if I sue you, you can sue me, right? So I doubt that they'll do it. We'll see. Also on the virus, new trade cases are being filed now during the virus. Indeed, trade lawyers in Washington, we're busier now than ever because there's so many new cases being filed. A rational person might think that industries would hold off on filing during the pandemic, but that's not happening. Everyone is extremely busy right now with new trade filings. And this is not just in the US, but other countries as well. So I think in the interest of time, Patrick and Bob, we may want to finish up there. We've gone a little bit over an hour. I hope that's okay.
As always, there's never enough time doing these cases. We could do a whole week on subsidies if anybody was interested and had the time. We might take just a couple of questions if anybody wants to ask a question live. Otherwise,
Patrick, let me just do this if I can. We've got three questions that have been posted. So let me address those quickly for us.
Okay.
The first one is, Indian government has given Apple and various other mobile manufacturers incentives for setting industries and for manufacture and export of mobile phones. Can this be challenged as a ground for subsidies?
I would think yes.
Yes. If Apple is manufacturing products in India and the India government provides assistance to Apple for manufacture of a good in India, then yes, that can be challenged on a subsidy case when those Apple products are exported.
Okay. The next question is, what is the de minimis rule?
Do you want me to take that?
Yeah, the de minimis threshold that we talked about earlier is that, as Patrick correctly noted, subsidy cases usually involve multiple subsidies. Let's say there's 5 different subsidies at issue. If collectively the result of, you add up each of the subsidies separately to get a total amount. If the total amount of the subsidy is less than 1 percentage point, then that's treated as if there's no subsidies at all and the case is dismissed. Okay? So that's the de minimis rule that we were discussing earlier.
Okay, the next question is, do you find subsidies law justified with a, I'm going to say TWAIL rating, TWAIL rating? Industries in the first world countries have been receiving so many tangible and intangible benefits since decades of inceptions like Ford and GM. How does the WTO expect third world countries, companies to compete with Ford and expecting a equal and really competitive market? Does WTO objectives of promotion of trade, does WTO objective of promotion of trade is merely equality prima facie, or does the WTO jurisprudence promote substantive equality and actually promoting trade globally?
Great question. Complicated.
Patrick, you start.
I would say that yes, the WTO does try to establish equality of conditions, non-discrimination. Now, it's certainly true in the past. I'm sure Ford and GM have received lots of assistance from the government. But I think today they would be treated well, as Spencer said, during the 2007-2008 crisis, China filed a countervailing duty case against the United States, and that was perfectly fine. So I guess GM and Ford cars exported to China were paying a countervailing duty. Anything to add?
Yeah, I would add, it is an interesting question. When you take a step back, it does seem unfair that the industrialized Western countries, which may have subsidized the hell out of their industries 50, 100 years ago, can get away with it, whereas a newly industrialized country, India, China, etc., Vietnam, that is now building up its industrial capacity, if they do the same things, they get hit with subsidy cases when 50, 100 years ago, General Motors and Chrysler and Ford did not get hit with subsidy cases. That does seem at some, inequitable, unfair from a high level perspective. But, I guess you'd have to say that the WTO members, when they negotiated the SCM agreement, I think the developing world accepted the bargain that they thought they would get enough out of the deal that even though they were subjecting their newly industrialized economies to these restrictions that the West did not have to put up with 50, 100 years ago, that the WTO developing countries still got enough out of the deal and other elements of the WTO that it was worth it to them. So I think the system recognizes that inherent inequity, but I think, and I defer to you, Patrick, who knows the overall WTO system better, I think the developing countries still sense that even with that inequity, it was still worth it to them to sign up to the overall WTO agreement. See what I'm saying, Patrick?
Yeah. No, I think that's absolutely right. I mean, you have to cut off the past at some point. You can't sort of go back 100 years to see what they were getting. Sadly, we're going to have to end here. Spencer, thank you so much for the usual really superb, clear, succinct. Might have been a bit, well, no, I wish we had more time. And I suggest now that we take a 5-minute break. I'm going to get another cup of coffee. You probably will be recharging your wine glasses or your whiskey and soda. And then in about 5 minutes, we'll get back to looking at other trade remedies. Okay, thank you.
For those
thank you so much.
And for those open and remaining questions, we'll have Patrick address those when we return before he starts his next presentation. And Spencer, again, on behalf of ILI and INALP, we thank you very much for your contributions.
Thank you, Bob. And once again, everyone, thank you for listening. And those are great questions. You guys have really thought about these issues. Thank you.
Okay.
Bye-bye.
Okay, and then I'll start your video right now. Okay, thanks.
Okay, are we live?
Patrick, you are now live.
Okay. Okay, short break.
Before we start your next
All right.
this segment, so we don't so our discussion isn't too disjointed, I suppose. I'm going to ask the 3 questions that really, I suppose, have some relevance still with subsidies, so we can keep these in continuity. Okay.
Yep. Yeah.
Okay. So the first question is, it was mentioned that the U.S. Removed India from a list of developing countries to the Developed Countries Club for trade purposes. Don't all WTO members have to follow the same WTO classification of developed, developing, less than developing countries? Or is each country at liberty to classify other countries based on its own criteria?
Well, I have to say, I wasn't aware of the point Spencer made. And in principle, yes, it's one of the curiosities about the WTO and the GATT system is that each country decides for itself when it comes in, whether it's developing or developed. And of course, because there are advantages of being a developing country, every country says this. And curiously, Singapore is still a developing country. Hong Kong is a developing country because there's nothing to require them, even though their GDP goes way, way up. There's nothing to require them to change. I frankly wasn't aware. I suspect this has to do with the withdrawal of GSP, the Generalized System of Preferences, from some products from India. But I wasn't aware that they had done this in terms of the countervailing duty. I'll check with Spencer and get back to you on that.
Okay. The next question is, only subsidies, I think this is more of a statement than a question, but I'll read it. Only subsidies resulting in lowering of costs can be challenged, or is it any subsidy, whether having a direct or indirect impact on costs, can be challenged?
The second is the right answer. You don't look at the effect on costs. Now, it's just, if there's a subsidy, then the assumption is that the company is benefiting from it in some way. It's being able to perhaps export at a lower price, etc.
Okay. Can WTO consider the appellate body if the case is resolved under domestic law? Can any of the party challenge the order of the domestic court in WTO?
Absolutely, and that's what's happened. Again, to go back to the lumber case, even the first decision, there have been 5 separate countervailing duty decisions. And in the very first one in the 1980s, I think Canada filed about 9 different appeals to the WTO, attacking the injury finding they attacked and won, the subsidy finding they attacked and won. And so the answer is absolutely yes.
Okay, and the last question, and then we'll start our next section, is, are there any exceptions to subsidy law?
I'm not sure well, yes, there is one. And if I can find it quickly, a lot of developed countries, developed countries and other countries as well, give export loans to companies. We have OPIC gives low interest export loans, and there's a special exception, if I can find it quickly, in the SCM agreement, which there's a definition of export subsidies as an appendix, and I think I can find it quickly. There's a wonderful exception. Spencer usually asks me to find this. Sorry, give me a second. Okay, illustrative list of export subsidies. And here is this wonderful exception. It talks about the grant by governments of export credits at rates below those which they actually have to pay, etc. But there's an exception to that if a member is a party to an international undertaking or on official export credits to which at least 12 original members to this agreement are parties as of January the 1st, 1979, or a successor undertaking, or if in practice, and that is basically the OECD rate. And so there's an exception for that. You can give export credits as long as they are at the same rate as, as used by the OECD. I hope that answers the question.
I think so. Okay, so let's move away from subsidies right now. We'll go into trade remedies, and I think you're all set.
Hang on. Oh, come on. What have I done? Sorry. God, I hate that. Oh, I should be using the arrows. Sorry, technically.
Yeah, just use your arrows and you can go back.
So, what do we mean by trade remedies? Well, basically, it is a way of a domestic industry that feels it's being adversely affected by imports to get some kind of relief, usually in the form of higher duties. Now, if you are an Indian company exporting to the United States, there are five possible avenues for relief. Dumping must be the most important, as we've already said, many more cases. So we'll look at that in more detail. Countervailing duties, we've really covered that now in terms of the SCM agreement safeguards. Those are the three principal ones, but in the national security has become an issue. We talked about that under the Trump administration. Unfair practices is a rather separate area. It basically deals with intellectual property infringement, where an import is the domestic IP holder believes that the imports are infringing its intellectual property rights. It can bring a case. And then something called Section 301, which, again, I'll get to, that can result in import relief as well. Now, again, here are numbers. These are investigations, by the way, and measures. The difference is investigation can lead to a measure. Measure is the application of anti-dumping duties or countervail duties after an investigation. So a number of investigations result in no finding of dumping or countervail, etc. But that will give you the numbers. Over 5,000 cases started on anti-dumping by the various WTO members, a huge number. And it's important to understand that even if it doesn't lead to a finding of dumping, it still is very disruptive to the industry, the exporting industry. It's a very intensive process. It requires a lot of work on the part of the exporters and disrupts the market. So that's, I think, important to understand that. So, dumping. What is dumping all about? Well, it's designed to counteract unfairly low prices of imports that causes harm. It's complex, it's very mathematical, and it's very easily manipulated. And that's why it's used so much. It's very easy. And there's a built-in bias because the dumping law requires the price, the exports, let's say to the United States, it must be the highest of the home market price or cost plus profit. So you've got two benchmarks. You must not only sell at or above your home market price, you've also got to sell at or above your cost and the profit. So that's a double test, and it means that there are many findings of dumping on one or other of those tests. And as I said, it's very burdensome. Even the investigation is very heavy. Now, who started this? Actually, everybody thinks it was the United States because the United States has been a very aggressive user of anti-dumping laws. It was actually Canada, because what happened was there was a steel monopoly in the United States. And as a result, prices were very high, monopolistic prices. The US industry said, well, why don't we now take over Canada? So what we'll do is we'll sell steel into the Canadian market, where there are, of course, Canadian producers at very low prices. We'll drive the Canadians out of business, and then we'll have a monopoly. That was the rationale for it. And then other countries followed suit. Is that economically sound? It might have made sense in 1904, but what would happen today if let's say, do a thought experiment. Let's suppose the US industry succeeds and manages to drive out the Canadian industry and is selling at very high prices in Canada. What would happen today? Well, there'd be competition. The Japanese would come into Canada, others. So in fact, there's enough competition now in the world market for steel or whatever it happens to be to make sure those prices don't get monopolistic. And that's why, as Spencer mentioned, most economists agree that the rationale for anti-dumping laws really doesn't make much sense. And the Supreme Court put it much better. I'm not going to read this, obviously, but we will be circulating these, and it's beautifully written. It said, look, nobody is going to take the risk of, by losing money for several years in the hopes of gathering a monopoly. There'd be too much competition. So that's really the economist's view of this. It's more seen now as a sort of safety valve, where you've got a lot of pressure against imports. Dumping is one way of relieving that pressure. Who are the traditional users? Well, traditionally, back in the 1980s, it was mostly these 4 developed countries or developed regions. But there's been a huge change, much more use, as we've seen the numbers. In 1958, there were 37 measures in force. They're now over 3,000, 3,600. Developing countries traditionally didn't use these. They had high tariffs. But as tariffs went down with the various rounds of negotiation, developing countries look more and more to anti-dumping, and more than half the measures since the WTO came to effect have been by developing countries. And most countries have dumping laws. Over 100 have measures in place, so it's very much become a part of the developing country arsenal against imports to help. But on countervail, it's still mostly these 4 countries, the 4 developed countries. Now, who is the leader? Most people say it's the United States, and traditionally the United States was the top user, but it's now moved into the silver medal. And who gets the gold medal? And I'm sure many of you know it's actually India. Many more than the United States, huge number of cases. So those are the users, India, but you can see that developing countries like India, Brazil, Argentina are now using this anti-dumping law very extensively. Who are the victims? Not surprisingly, China is by far the largest victim, and then followed by India's high up, it's number 6. So that will just give you a sense of how many cases there are and who is really using them. In terms of India as a complainant, India's filed more cases against the United States, and then the EU, South Africa. And then as the victim, China has filed many cases against India, and then you can see the others. The US is about 42. And then CBD cases, as Spencer said, many fewer cases, only 8 cases against China. And India has been the victim of 34 cases, countervail cases brought by the United States, etc. You can see the numbers. So what are the rules on dumping? The anti-dumping agreement, one of the Uruguay round agreements, it does 2 things. It sets substantive rules for calculating dumping margins and determining injury, and it provides procedural protection. You probably use the term due process. It's not full due process, but it does give the right to the respondents in cases to present their case, to testify in an open hearing, etc. So that is the idea. And obviously, every member their dumping laws, their domestic laws must be consistent with both GATT Article 6, which has some very rudimentary rules on dumping, and the Uruguay Round Anti-Dumping Agreement. Okay, what is the definition of dumping? Sales below normal value, and we'll see what that means, causing or threatening to cause material injury to domestic industry producing the like product. Remember, I think I said that the like product term is used 47 times in the WTO agreement, and here's another one. So that there must be a domestic industry producing the like product, and you use the same definition as we've talked about in terms of Article 1 and Article 3. And as I said, under the US dumping law, a like product is defined as a product that is like, or in the absence of like, most similar. That gives you a lot of flexibility. Okay, so the first thing we need to know is what is the export price, because we're comparing that with normal value. Where the importer and exporter are unrelated, it's simply the price between the two, because the assumption is that since they're not related, it's a market-driven price. It's driven by competition, etc. But what if the importer is related to the exporter? I use the case of Toyota. Toyota Japan makes the cars in Japan, and then it exports them to the United States, and they're imported by Toyota US, and then Toyota US in turn sells them to distributors. Well, the price between Toyota US and Toyota Japan and Toyota US may not be a market-driven price. It may be affected by tax laws. They may design the price so that the taxes are minimized. And so, generally speaking, in that case, you would use constructed export price. And that basically means you take the price, the first unrelated transaction, which would be Toyota US's sales to, let's say, distributors, if it's unrelated. And then you have to back out various ways. It's complicated. But anyway, that's the basic idea. So what is normal value? It's a little complicated, the definition, and I don't want to spend any time going into it, but essentially it means home market sales at or above the cost of production or cost of production. And as I said, it's really a dual test. If it's below one of those, either home market sales or cost of production, then that is treated as dumping, if your export price is below either of those tests. Now, important to note, it doesn't apply to China or Vietnam because they're treated as so-called non-market economies, and we have a different test, and I'll explain that in a few minutes. I'm going to jump this, but basically the sales below cost test is very unfair, and it does lead to a lot of dumping cases. Basically, it's the fully allocated cost. You can go through this and you'll see that a company should stay in business selling, even if it's making a loss based on fully allocated cost, as long as it's covering its variable cost. But as I said, because of time, I don't want to get to that in detail. Now, there are a lot of adjustments to export price and normal value. If you just simply took the export price, let's say it's Toyota US's sale to its independent distributors, well, that price, can you just compare that price directly without adjustments to the price at which Toyota Japan is selling the cars in the Japanese market to their distributors? Well, the answer is no, because there are a number of costs that will be different. For example, transportation. It would have cost quite a bit to get the car from from Japan to the United States and then to the distributor. Well, that should be built into the price, and so it should be a higher price to reflect that. There may be other differences. There may be a better warranty terms given in Japan than the United States, or the terms of payment may be different, warranty, credit expenses. So many adjustments, and these involve a lot of work on the part of accountants who play a very important role in these trade cases, these anti-dumping cases. So that's gives you some idea. Again, I don't want to go into great detail here because we don't have the time, but the Uruguay-Iran price says the comparison must be fair, and it must be either the average home market price, normal value, to the average US price, or transaction to transaction. Again, this is quite complicated and we really don't have time to get into it in detail, but if anybody has questions, then happy to take those later. Now, very important case called zeroing. It's been more litigated than any other single issue in the WTO, and not just on anti-dumping, on any issue. There've been, I think, at least 20 cases, and it's the main reason, the cases against the United States on the so-called zeroing, which led to the US not refusing to nominate people to the appellate body, and the reason that the system is now not working. Very important case, and interesting, it was brought by India and against the EU, and it was on bed linen. So now, just to explain quickly what this is about, and the numbers I think speak for themselves. Let's suppose, to make it simple, there are probably hundreds of different types of bed linen, different sizes of sheets, different pillowcases, etc. But I've taken 3 products, and let's say the volume is 100, just to make life simple, and there's a dumping margin calculated on each separate product. And let's say it's 12% dumping margin on sheets. On pillowcases, it's -6%. In other words, they're not dumping, they're doing the reverse. They're selling for a higher price to Europe than in India. And comfort is 0, just to make the calculations easy. Now, the true average, because then after they've calculated a margin for each individual product, then they take a weighted average for the entire product for bed linen. So a true average would be, if I think the maths are right, it's 2%, which is 6 over 300. I think you can follow the maths. But the US position, the EU, and then followed by the United States, said, well, no, we're not going to give you credit for your negative dumping. We're going to treat that as zero. And that's why this is called zeroing. And then the average becomes 4% because it's 12 divided by 300. Now, is this fair? And the United States litigated this, I would think, at least 20 times. And the basic position was the US said, look, there's nothing in the dumping law or the dumping agreement that says we can't zero, and therefore we can. And the appellate body said, no, there's nothing in the anti-dumping agreement that says you can zero, and we think it's unfair. That was the issue, and that went on and on. The US has finally given up, but they kept doing this again and again. And so, as I said, India started this. It's a very good decision and very bold, I think, of India to take the case. Non-market economies, what is normal value? Well, home market price, the assumption is it's not market driven, it's driven by government intervention. And so then you look at factors of production and you calculate the factors. You don't look at prices of raw materials or labor. You look at the number of hours used to make the product and the quantity of raw materials, energy, etc. And then you take those factors and you value them based on a market economy at a similar stage of development. India has been used, Indonesia. It can lead to very distorted results. Spencer was involved in a case on honey from China, and they took the price, the Commerce Department took the price of honey based on a newspaper article in India saying that the cost of raw honey in India was between 20 and 40 rupees a pound, if that's the right number. And so the Commerce Department said, right, we'll take the average 30. Well, who could have predicted that? Is that really a way? So you get very unpredictable results. And as Spencer said, very high margins in some cases. Okay, now the injury determination, the anti-dumping agreement requires the investigating authority, which in our case is the International Trade Commission. Very often it's the Treasury Department, or Ministry of Commerce possibly. And they have to look at the condition of the domestic industry, because the question is the domestic industry being materially injured by the imports? So you look at this range of factors, looking at the state of the industry. We don't need to go through those, you can read those. And this is where economists play an important role. Certainly every major case, each side has an economist to analyze all this data. And a lot of the data, by the way, in our case and every other case, every other country, the investigating authority sends out questionnaires to the domestic industry to find out what is going on, what are their sales, what are their profits, prices, etc. So then they also have to look at the impact of imports. Are the imports a cause of material injury? And here again are the factors that you look at. Are imports going up? Are they taking a significant share of the market? Is the domestic industry losing sales to imports? What is the level of imports compared with the domestic market, etc. So that's all fairly straightforward. Also, a case can be based on threat of material injury. And maybe an analogy is that if somebody points a gun at you, you can actually ask a policeman to intervene before he pulls the trigger. And this is the same idea here, that even if you're not being actually injured now, if there's a real threat that you will be injured, you can bring a case and a dumping order can be based on a threat. And again, here are the factors that was looked at, not just some speculation. You've got to really think this is going to happen quite soon. And again, the factors are laid out there. Procedures, now I've set out the US procedures because I know them the best, but basically it's quite a complicated procedure. In our case and Canada, and I think the only countries, as far as I know, that do this, there are actually separate agencies that the Commerce Department, in our case, decides whether or not there's dumping. The International Trade Commission decides whether there's injury. And you go through a series of preliminary decisions and then a series of final decisions when the parties have had the opportunity to file written briefs and to appear at a hearing. Now, where does the information come from? Once a dumping case is initiated, in our case, again, India will similar, the Department of Commerce sends a questionnaire to the foreign producers to find out what their prices are in the home market, what their prices are at the United States, what their costs are, if cost is an issue, which it usually is. And how does the Commerce Department know that that information is correct? I think a foreign company could just make it up and to demonstrate there's no dumping. Well, we have a process called verification, which is quite controversial. And this is authorized by the anti-dumping agreement. The investigating country, and again, I'm using the US as an example, will send a team of their employees, usually an accountant and other investigators, to the foreign companies and go through their books and records very carefully for a week, or it could be 2 weeks, sometimes 3 weeks, really a very intense audit. And to make sure that the information that has been sent to the Commerce Department, it ties in with the regular books and records. It's a very intense process, can be very difficult. And what happens if the verification fails? If, in other words, the books and records don't match the information, then the investigating authority can use what is called best information available, which basically means the highest margin they can come up with. So it's the only lever they have. Obviously, the Commerce Department can't go, let's say, to Japan and ask the Japanese courts to force the company to provide the information, but this is the weapon that they have. And in a lot of Chinese cases where you have a lot of small producers, they don't understand, or they simply can't be bothered. And so you get a lot of these very high margins result from a failure or a refusal to verify. Sometimes companies just say, please go away. And then if you've got a final affirmative injury finding and a finding of dumping, then you get an order, and then the duties are assessed on imports based on the finding by the department. Okay, this is just giving an idea. These are the cases just against the United States. And I'm frankly, I think there are a few more that I haven't added. I obviously don't want to go through these detail, but many of these cases, and you can see the word zeroing in some of them, and quite a few of them, although they don't use zeroing in the title, they did involve zeroing. So you can see, and other cases as well against other countries, but not nearly as many.
Patrick, I'm going to jump in here just for one real quick question.
Yeah, sure.
So we're on topic. What is the difference between zeroing and averaging? How does averaging work?
Okay, let's take the bed linen case. Let's say there are 200 different categories. There are different size sheets. There are different size pillowcases. There are different materials. And so you can't compare the price of a king size sheet with the price of a regular sheet. You've got to look at that, and you just compare the same product with the home market price or the cost with the export price. But that would mean if that was in the order and you told the customs service, whoever's collecting the duty, to collect 1,000 different rates, it would be incredibly complicated. So at the end of the exercise of determining margins for each individual product, then to make life easier at the customs end, they average the margins into one rate, and that would apply to all bed linen. It's just sort of a way of simplifying the task. Now, so the question of zeroing is when you're averaging, the second stage is taking the individual margins and averaging them to get one margin for all bed linen. What do you do about the negative margins where the company is doing the reverse of dumping? It's exporting at a higher price than the domestic price. So it's the reverse of dumping. Well, if the zeroing means you treat those as zero, you don't give credit, if you like, for the above normal value sales. So that's the issue. And the WTO has now ruled of the many cases that is not legal under the Anti-Dumping Act. It's not fair. I think that's the way they decided the case, because if you remember, the dumping agreement requires the price comparison to be fair. I hope that answers the question. It's a very complicated issue, and again, we could spend. We've done some courses for Chinese lawyers a long time ago now, but literally 3 weeks just for dumping and countervail. So if anybody wants to do that, let us know, and we'd be happy to arrange it. But I hope that to some extent answers the question. Okay, move on. Okay, so I should add also that countervailing duty cases, or the anti-dumping, the SCM agreement sets basically the same procedural protections as in the anti-dumping agreement. So we don't need to go through those, other than to say that the time limits are slightly shorter because you're not dealing with a number of different manufacturers, you're dealing with the government, and so it should be quicker. But that's the only significant difference. So basically, the same procedural protections apply to countervail. They're handled in exactly the same way. In our case, it's the Commerce Department that does the subsidy investigation and the International Trade Commission that does the injury investigation. In most cases, as I said, most countries, it's one agency which does it all. And again, there's not much. So no. What about safeguards? What is a safeguard? And I should say they're incorporated in most trade agreements. And the difference, there are two important differences between dumping and countervail on the one hand, and safeguards on the other. The idea of a safeguard is to give a domestic industry temporary protection where imports have increased and they're causing harm to the domestic industry. But it's temporary, and I'll explain that in a few minutes. Also, it's no fault. It's not directed at unfair practices. Dumping and countervail duties are directed at unfair practices, either dumping, selling below normal value, which is considered unfair, or subsidization, which, if it meets the definition of subsidy, is considered unfair. But here, there's no fault. It's just simply that imports have increased. The foreign producer is more efficient, perhaps, or is expanding. And so that's another important difference. And finally, unlike dumping and countervail, which is, we've said, apply country by country, each dumping order applies to one country only. And this safeguards apply to imports from all countries, but with some exceptions. Okay?
Hey, Patrick,
Yes.
While you're changing slides,
Yep.
do you think negative margins should be included while calculating average margins?
Well, the WTO certainly does. It's ruled about 20 times that it should. It's a good question, and certainly the U.S. of course says no. It's not. It's not. We can leave those out if you like and treat it zero. I think. I think on balance, I would say it's unfair, but I can see the arguments for saying that it's perfectly okay to zero. But it's a great question. It has been the most litigated issue, not just on the anti-dumping agreement, but of any issue in the WTO litigation process. It's been more litigated than any other issue. And as I said, basically is the main reason why the US is no longer supporting the appellate body, and the dispute settlement system is now in limbo. So it's a very, very important issue. But there are arguments on both sides, to be honest with you. Okay. All right, moving on. Here's what the GATT Article 19, the original GATT has a provision allowing the use of safeguards, and this is greatly added to by the WTO Agreement on Safeguards. It goes into a lot more detail. Basically, there are 3 criteria that must be satisfied before a party can impose safeguard. And they can, by the way, usually they're in the form of additional duties, but they can also be quotas. Unlike dumping and countervail, where anti-dumping or countervailing duties are the only remedy, here you do have a quota remedy, which does happen from time to time. So, 3 criteria. Imports must have increased. Now, it could be a relative increase. They could have gone down in absolute terms, but taken a larger share of the domestic market. They must result from unforeseen developments, something that you didn't expect. It's really, I'm sure you're all familiar with the force majeure doctrine, that if when you enter a contract with someone and there's something really that nobody could see coming changes the terms, then you can get out of your contractual obligation. This is the same idea. If something completely unforeseen happens, to give an example, we applied safeguards to steel after the East Asian financial crisis. And the argument made by the United States was, well, nobody saw the financial crisis in East Asia in the late 90s, I think. And that resulted in steel demand going down in Asia, and then more exports to the United States. And then there was cause of threatened serious injury. Remember, dumping countervails material injury, which isn't very much. whereas this is serious injuries to domestic, like or directly competitive products. Again, like products, but also going a little broader to directly competitive. Now, this is important. Any party, any foreign country which is affected by a safeguard, its exports are affected, it has the right to consult, which is the old diplomatic process behind the GATT, which I mentioned to you, but then to compensation or retaliation. So let's say the United States applies safeguards to steel. Japan, let's say China is exporting a lot of steel to the United States, and so they're affected by the higher duties or the quotas. Now, because there's no unfair practice here, there's nothing unfair about what China did, and ignore anything to do with countervailing duties or anti-dumping, but they're entitled to compensation. And if you remember, we talked about the idea of reciprocity. Now, what has happened is by imposing a safeguard, by imposing duties or a quota, the United States has upset the balance, the theoretical balance. So China is now entitled to some sort of compensation or retaliation to make up for the loss of export sales of steel. It might be a lower duty by the United States on other products. We'll get into this in much more detail when we get to when we get to dispute settlement. But the important point about safeguards is it's not a free remedy. If you apply dumping or countervailing duties, then that's fine because you're offsetting an unfair practice, what is supposed to be an unfair practice. Here, there's no unfair practice. So the idea is to keep the balance the same by adjusting tariffs on other products. We'll get into that in much more detail. So moving along, procedures very similar to the procedures under countervail and dumping. You must hold a public investigation. You would supply reasonable notice to all interested parties, particularly exporters, and they have the right to present their views and evidence. You have hearings, and you must publish reports setting out the findings and conclusions in great detail. And the W has been very strict on these. Now, what is serious injury? As I said, material injury, which is the definition of injury in the dumping countervail, is not very much, just a little bit more than de minimis. Sometimes it's been found. Serious injury is a lot more injury. It's serious, significant overall impairment in the position of the domestic industry. And again, you can bring a case based on threat of serious injury, but again, it's got to be something that's just down the road. It's not something that might happen in 20 years' time. Now, sorry, go back one. And here are the factors, very similar factors to the ones that set out in dumping and countervailing duties. You look at the rate and amount of increase in imports, what are the import share of the domestic market, and how have things changed. Normally they look at a 3-year time span and have imports gone up during that period. What's happened to the domestic industry? Is it going down? Is it losing sales? Is it losing profits, etc.? And there must be a link between the increased imports and serious injury or threat. If you're defending a safeguards case for the foreign exporters, you look for other reasons for the problem that is being suffered by the domestic industry. They may have made bad management decisions. They may have had a fire at the factory and therefore their production's gone down. So you're looking for other factors. Okay. No, as I said, it's a temporary remedy, not a permanent remedy. Dumping and countervailing duty orders really remain in place. You can try to get them removed if you can show there's no domestic industry left or there's no longer injury, but it's very difficult to do. Whereas in safeguards, they normally cannot exceed 4 years, but you can apply for an extension for an additional 4 years. This is all, of course, under the safeguards agreement. I mean, this is embodied in domestic law, but it's, and then you can get an additional 4 years if you can show you need it because you're still, if the safeguards are lifted, you will still suffer serious injury, but also that the industry is adjusting. In other words, it isn't just sitting back and saying, oh, good, we're making more profits now, prices have gone up because of the import relief, and therefore we'll just make more profits and hand out more dividends. You've got to show that there is some adjustment that is going on. I was involved in a big case quite a number of years ago now on copper we represent the Chilean government, which is the largest exporter. And our argument was very simple. There's nothing the US industry can do. Yes, they're not doing well. They're losing money and so on. But the problem is they'd mined out all the good ore. They had the copper ore in the United States had very little copper in it, whereas Chile had a tremendous copper. Well, what could the industry do? They could do nothing about the ore, and we won the case based on that. And then you've got to pause for 2 years before applying another safeguard. Not nearly as many cases, but India, interestingly, is the most active user of safeguards, followed by the United States, not very many, about 12 cases, etc. So India, again, very active, most active user of dumping laws and of safeguards. India's a big economy. Yes, sir.
Patrick, can a country impose safeguards as per their judgment, or is there any aspect of proportional safeguard?
I'm not quite sure what's meant by proportional safeguards. Maybe when we get, after we finish this presentation and we go into a live discussion, maybe the person could raise it. Do you mean, can you apply different tariff levels to different countries? The answer is, I don't think that's ever been done. And I'm not sure whether it would be legal. I'd have to think about that. I can't give you a definite answer.
We'll have a small
we'll have a live discussion,
voluntary open session afterwards, so maybe we can redefine that.
Okay, now we see other safeguard provisions. This is the general safeguard built into the WTO system, but the Agreement on Agriculture has special safeguards, and interesting, these are not based on a showing of injury or threat of injury. They're simply based on numbers. If prices go down or imports go up, then there's an automatic provision. And then free trade agreements almost always have what is called a snapback provision, that if there is injury caused by the increased imports resulting from the abolition of tariffs or the reduction of tariffs, then you can snap back to the original most favored nation or the most favored nation rate. So again, you see that from time to time. Okay, now here are the cases on safeguards, or some of the principal cases in the WTO. Again, the US is by far the largest victim of safeguard cases, showing that we're very active. Although India's applied more safeguard cases, it has never actually been challenged in the WTO. Couple of new cases, a long time. The last case until the Trump administration was in 2002, in the steel case. And the interesting issue there was, what was the cause of the increased imports and the fact that the U.S. industry was doing very badly. They were losing money. The U.S., as I said, they said, well, the unforeseen development is the cause of the injury is increased imports from East Asia, because demand for steel in East Asia has gone down because of the financial crisis. But the WTO said, no, that's not as important. The more important issue is what are called legacy costs. In the 1980s, the US industry laid off a lot of workers. They became more efficient. They had better, more efficient steel mills, and they laid them off, but they gave them very generous terms, very generous pensions, health benefits, and so on. The so-called legacy costs. And the WTO said that was the major cause of the injury. And then there were two cases which were filed by the Trump administration: solar cells, washing machines. And again, they applied tariff rate quotas, which I think I mentioned the first day. That is a two-step tariff. A certain quantity, the quota amount, is allowed in at a low rate, could be 3%, 5%, but pretty low rate. And then after that quantity has come in, the tariff rate goes up. And in this case, the above quota rates were 30% in one case, 20% in the other, and 50% in parts. So that gives you an idea. Now, we talked at length, and I don't think we need to go into this again in much detail, is the national security. This is based on Article 21 of the GATT, which we looked at on the first day. And under US law, Section 232, they're known as 232 cases, the Commerce Department advises the president whether imports are threatening to impair national security, and to advise him on remedies. The president has complete discretion as to what to do, and not many cases until the Trump administration came in The last case was 17 years ago. And again, to give you an example, the US industry that was producing ceramic bases for semiconductors filed a case, and they said, look, 90% of the entire market in the United States is supplied by one company in Japan, Kyocera. And if you allow them to continue, we will go out of business and the US will not have its own industry at all. And if there's a war, we won't be able to get semiconductors from Japan. And we represented Kyocera, and the finding was that, well, in fact, the entire US industry could be supplied by one jumbo jet of semiconductor bases from Japan, and that in any reasonable type of war, probably one jumbo jet would get through. So they threw that case out. But now we've got these new cases. We've got aluminum and steel, mainly aimed at China, but it covers all imports with some exceptions. And the two cases where there was a finding of national security, and we've applied these tariffs to, aluminium. I'm sorry, I said before, I've been in this country for too long, and steel. And as I also mentioned, and there's an investigation on vehicles, and then some new investigations going on listed at the bottom. Now, as we said, this is really the time bomb, and I think we discussed this in detail yesterday. The US position is you have absolutely no right to investigate this. It's a security matter. We alone can judge whether it's necessary for the national security, because that's the term says it considers, i.e. the country imposing the relief, it considers necessary for national security, and we have the right to decide that, and nobody can, particularly a panel of the WTO, has no right to second guess. I also mentioned there's a case in Ukraine v. Russia. The panel has said, well, forget about it, considers necessary, but it also has to be in time of war or other emergency, and we have the right to review that. In the Ukraine case, the WTO, the panel said, well, yes, actually in this case, there is war or emergency. Russia has sent soldiers into Ukraine, but the point is they said we can review it. And so in a panel, and several countries have challenged our use on steel and aluminium, and that will go to a panel. And this is basically the panel can make that decision. And I think it'll be much harder for the US to argue that import relief against countries like Canada and Mexico, friendly neighbors, is really a problem of war or other emergency. And there are two other cases which are pending. Okay, Section 337, we don't need to spend a lot of time on, but again, Indian exporters to the United States should know about this. This is mostly applied to intellectual property rights. If you are a intellectual property owner in the United States, and you think that somebody else is infringing your patent or your copyright or your trademark, and if it's a US company that's doing this, you can bring a case in a US court. But what do you do if it's a Vietnamese company exporting to the United States? You can't bring it to court in the United States because it doesn't have jurisdiction. The company is in Vietnam. You could go to a Vietnamese court, but I don't know much about the Vietnamese courts, but I suspect, like the Chinese courts, there's probably a lot of bias in favor of the domestic parties. And so instead, you have the right, and this is again authorized by the WTO, and you have the right to go to the International Trade Commission in our case. And if the International Trade Commission finds that there is an infringement of an intellectual property right, then they can issue an order blocking all imports. It's a very effective relief. It's quite detailed. It's more like a regular court procedure with discovery of documents and so forth. And I've been involved in a couple of them. They're very complicated. A lot more cases recently. I suppose there's a lot more imports and a lot more potential infringement. So that's all I need to say. Then Section 301, this is an interesting, can result in import relief, but it's designed not to deal with injurious imports to the country bringing the case, but actually to remove foreign trade barriers where a foreign country is doing something which is inhibiting US exports. Then the Section 301 allows a company to file a case, and then the president can review the case, and if they find there is a violation, then he can impose, well, there are all kinds of relief, but one is duties on imports from that country, basically punishing that country by imposing duties or other import restrictions. So it's very broad. This has not been used for quite a while, but it was used. As you know, we've applied a lot of duties to most imports from China, and it's based on intellectual property violations by China, transfer of technology requirements. An American company that does a joint venture with a Chinese company to do business in the Chinese market is often required to supply its own technology, and that's considered unfair. So that just gives you an idea of how it's used. But China is the only time I think we've applied it, certainly in recent years. And so it's probably not much of a threat. But again, I just want to give you the comprehensive idea. And I'm sorry, there's a current investigation now on the French, the DST, the service tax, and the US has threatened retaliation. France has said, right, we won't apply it yet. Let's wait till 2020. There's a new investigation on 10 countries, which just started recently. Now, the OECD is looking at this whole question of the digital service tax, sorry, DST, digital service tax, to try to come up with some agreement which will not lead to punitive measures. But anyway, that's certainly a very important and very current investigation. Okay, I am afraid that was a very rushed presentation. I do apologize, and I know I was speaking very quickly, which is a problem, but I did want to try to give you an overview. There's obviously much more detail if we'd had time to go into. So, any more questions, Bob?
Yes, Patrick. So actually, we're as close to the proper time as possible, which I suppose is good. So I'm going to give you two questions. I will then, again, as we did yesterday, for those who wish to stay, we'll take a short break, maybe 2-3 minutes. I'll open up the microphones for all those individuals who are remaining, and we can have a more open discussion. But the two remaining questions that were posed during your presentation is, does a country imposing safeguards need to compensate all other WTO members for its injury caused to the industry due to it?
Sorry, could you just read it again?
Sure.
I missed it.
Does the country imposing safeguards need to compensate all other WTO members for the injury it caused to the industry?
Whew, that's another, God, you are asking incredibly good questions. It might depend on the volume of exports that are being affected in small countries. And there's some curious exceptions to the safeguards on steel and aluminium. Now, Korea was accepted because we had just renegotiated the KORUS agreement, the Korean Free Trade Agreement with the United States. And one thing the Koreans agreed to was to restrain exports to the United States. So they said, right, we won't apply safeguards because you agreed. Australia got an exception, and nobody knows why. Literally, there's no logical reason. It's believed that President Trump had a conversation with the Australian Prime Minister at about that time, and that maybe he agreed to exempt it. But there's no logical reason. Korea there is, because they've agreed to restrain exports in a different way. Small steel exporters, in theory, they could apply for compensation, but if it's only a small volume of trade, it might not be worthwhile. But in theory, yes, any country that is affected by a safeguard, adversely affected, has the right to compensation.
Are safeguards only applicable when imports are increased, i.e. tariffs are dropped?
That's a great question. Under the original Article 19 of the GATT, it had to be an absolute increase in imports. But the agreement, the safeguards agreement, as part of the Uruguay round, found that, it stated that a relative increase in imports would be enough. So let's say, for example, the total market for the particular product, let's say, is $10 million. And let's say it goes down to $8 million. Did I say billion? Let's say $8 billion. No, $8 million. And so the absolute market has gone down. Now, let's say that imports had $5 million worth of imports. So it's 50%, but then it remains at that level. So now it's got a larger share of the US market. It's got 5 over 8 instead of a half. And so that is now would be considered an increase in imports. So it's a relative increase is enough.
Okay.
I hope that answers the question.
Patrick, I'm going to suggest to yourself and to the attendees and the brief, let's take a 3-minute break. Let's get resettled. It'll give me enough time to open up the microphones to all of our attendees.
Okay.
And then we can open up for any questions or comments. And we'll spend about maybe the next 15-20 minutes there, and then we'll close up for today.
Okay.
Other than that, I think we are everyone who has availability to participate in speaking is now at that status. So in about a minute or so, we'll start, Patrick.
Sorry, are we on now? Are we live?
Yeah, we're still live. We haven't left.
Okay, because I was just looking, Sarah D'Souza, who asked a number of excellent questions yesterday, has asked another very good question. What if there is a subsidy that is later taken away by the government, contravening the legitimate expectation? Is there any remedy against this? I think my answer, it's a great question again. Oh, okay, so yeah. The answer is, I don't think there's any remedy in trade law. On the other hand, there might be a remedy under domestic law. If the government had made some promise and it's reneged on its promise, then as I said, it would be entirely a question of domestic law, whether or not the government has violated some term of its or some agreement. I hope that again answers the question.
Okay. And again, if anyone has a question, just turn on your microphone, introduce yourself, and please ask your question or comment or scenario.
Hello.
Hello.
Yeah. Hello, sir. This is Ashwin from India.
You right?
Yeah, sir. So my question is that, regarding subsidies. The query which I have is it only subsidies which result in lowering of costs which can be challenged, or is it any subsidy, whether having a direct or indirect impact on the cost, which can be challenged?
Yes, you don't look at the impact on cost. You just simply look at, is there a subsidy? And the assumption is it probably does have an impact. And certainly just the idea, and again, I want to reiterate, the idea is it something that distorts investment? And a subsidy to the steel industry, let's say a tax credit, would clearly distort investment decisions. More people, more companies would invest in steel than would in a completely free market situation. So that's basically the test, and that's why we have the specificity test. The argument is that if a subsidy is made generally available, that most people can benefit from it, or most producers can benefit from it, then it's not distorting investment decisions. That's the idea. So we only look at subsidies which are specific, they are tailored, or they result in benefits going to one or a few industries as opposed to generally available. Again, the answer to a public road, everybody benefits from that. Education, everybody benefits from that. And it would be, if you allowed people to file countervailing duty case against the cost of educating a company's workers, you can understand what would happen. There'd be endless countervailing duty cases. So that's the purpose of the specificity test, is to narrow down the number of cases where subsidies could lead to investment distortion.
Thank you, sir.
Anything else? Either you're totally confused or you understand everything. So,
we all take credit for the latter.
Probably not. I do apologize. I wish I'd had 2 hours for this presentation, but we just don't have the time. So if there are any other questions, I'd be very happy to try to answer them. And once again, wonderful questions. This has been, I think, some of the best questions that I've ever encountered in teaching this course many, many times. So It's really very, very impressive.
Well, I do know that it's getting late in India. So if we do not have any additional questions or comments or clarifications, we can conclude here. If anyone does have one final issue that they'd like to raise, please do so now. Otherwise, we'll let everyone have a good evening, good dinner.
Sarah has a question.
Yes. Good evening, sir. I was just a little confused about the whole aspect of margin calculation and the normal value, in the sense that what role does the normal value play when you are in the context of zeroing? Because I didn't understand exactly how that works.
Okay, very good question. Well, normal value is the benchmark against which you test the export price. So again, I'm just using the US because it's the US, let's say there's a dumping case on a particular, let's take benylinen. The EU is they're applying dumping duties to imports of bed linen from India. Now, the normal value is either or both the price of the like product in India and the cost. It's got to be at or above cost, and it's got to, in general, there are exceptions. It's got to be, generally speaking, at or above cost and at or above the home market price. So that's the basic test for normal value. Now, and again, this gets a little bit complicated, but with the bed linen example, many different types of bed linen, different sizes of sheets, different types of pillowcase, different materials, probably different levels, qualities of cotton. So you've got many different products. Well, you can't compare the price of a sheet in India with the price of a pillowcase in Europe. It wouldn't make sense. So basically, you look at each individual product. You compare the price and the cost in India with the price to the European Union, and so each one you calculate an independent margin. But it would be incredibly complicated for your customs service in the EU to apply maybe 1,000 different rates for each different product. So at the end, when they've calculated the margins for each separate product, then they are averaged. And so one average, you get one rate for bed linen, let's say 5%. So every item of bed linen that comes in, let's say it's a pillowcase or a sheet or whatever size of sheet or whatever, it pays the same 5%. So that's an average of all the individual margins. I know it's complicated, and I wish I had a blackboard that I could use to illustrate this better. Now, the zeroing, the question is, what do you do? Some of these products may not be dumped. They may be the reverse of dumped. In other words, they may be sold to Europe at a higher price than the cost or the price in India. So what do you do? Do you put that into the average or not? And that is the zeroing issue. The United States and Europe said, no, we're going to treat that as zero. We're not going to give you credit for selling above your normal value. But the WTO has held again and again that no, you must take those positive margins into account in calculating the average. And so the zeroing process of just treating negative dumping margins, if you like, higher than normal value at zero results in higher dumping margins. So that's the whole idea. It's a way of manipulating prices, manipulating the comparison to raise dumping margins. And that's why the WTO said you can't do it. And just again, I think I said this before, but the US position has been, look, there's nothing in the dumping agreement that says we can't zero, and therefore we can. And the position of the WTO was, no, but there's nothing that says you can zero, and there is a requirement that the comparison be fair, and we think it's not fair to zero. Now, again, there are arguments on both sides of that. And I mean, my inclination is to say zeroing is unfair, but that's because I've always represented importers. And so we don't like mechanisms that raise the dumping margins. Does that help, Sarah?
That does so. Thank you.
Yeah.
Thank you.
Not at all. Pleasure. Okay. Are we done, Bob?
I'm sorry. So with that, we will conclude our program for today. Thank you, Patrick and Spencer. And for all of our attendees, we'll see you again here tomorrow. And have a good evening. And thank you for your time and patience today.